The CTA is being sued. Well, not technically. CTA is an act and you can't sue an act. But there is a lawsuit pending in federal court challenging the constitutionality of the Corporate Transparency Act and requesting a hard stop on its moving forward. Come hang out for a while and let's dive into this complaint. If you watch to the end, I summarize it all and share my thoughts on whether the challenge will be successful. Hi guys, welcome to Presume Legal. I'm Misha Janice. I'm an entrepreneur and attorney licensed in New York and Florida. Today we're going to look at the first legal challenge to the Corporate Transparency Act. Plaintiffs filed suit against the U.S. government in 2022. The case has been pending since then. Since the complaint was filed, and we're going to read through the complaint in just a minute, there's been a motion to dismiss and for summary judgment, as well as an amicus brief. Now, amicus briefs, if you haven't heard that term before, translates to friends of the court. And they are briefs filed with the court from third parties who are not a party to the lawsuit, but they are in support of one of the parties and their positions. So we're going to turn to look at the complaint now, and then I'll summarize key points once we're finished. All right, here we have the complaint that was filed against the U.S. Department of Treasury, Janet Yellen as the Secretary of the U.S. Department of Treasury, and Himamaldi Das, who is the acting director of FinCEN, the Financial Crimes Enforcement Network. We know FinCEN is the agency that has been tasked with implementing the Corporate Transparency Act. So this was a complaint filed a year ago in November 2022 in the Northern District of Alabama. It was filed by the National Small Business United, that does business as the National Small Business Association. I'll refer to them as NSBA. And an individual plaintiff by the name of Isaac Winkles. So I think what we'll do is, this complaint is 38 pages long. I may skip around just a little bit and not read every single paragraph, but I just want to get some of the basic details here. And this is actually the first time that I'm going through this complaint as well. So let's get into it. All right, the complaint starts. Plaintiffs, NSBA, and Isaac Winkles, major shareholder of an NSBA member, bring this civil action for declaratory and injunctive relief against Janet Yellen in her official capacity as Secretary of the United States Department of Treasury, also Himamaldi Das, and the Department of Treasury itself. Preliminary statement. Justice Louis Brandeis once warned in a dissenting opinion that would later become law that the greatest dangers to liberty lurk in the insidious encroachment by men of zeal, well-meaning but without understanding. And there's some citations there. This doesn't really belong in a complaint, but I guess they're just trying to give the lay of the land, set a stage, set the scene, as you will. It goes on to say the Corporate Transparency Act, a federal statute enacted on January 1, 2021, mandating that persons forming entities under state law report sensitive information, quote, sensitive information, to the federal FinCEN or face monetary penalties, imprisonment, or both, is just such an insidious encroachment, quote unquote. The CTA's reporting requirements will apply to approximately 32.6 million, quote, reporting companies in 2024, and to an estimated 5 million additional companies per year thereafter including the vast majority of NSBA's members, located on every main street in America and in every corner of every state in the Union. These reporting companies, and I'm just going to skip over these citations. Um, I don't know if anybody's looking anything up, but if you do want to look it up, you can see the citations on the screen. These reporting companies include mom and pop businesses, franchisees, manufacturers, online retailers, plumbers, restaurateurs, electricians, mechanics, lawyers, architects, dentists, doctors, fitness studios, landscapers, and any other privately owned enterprise or business with 20 or fewer full-time employees or less than $5 million in annual gross receipts or sales. But the CTA goes further. It also covers entities that are not engaged in any commercial activity at all, including one, not-for-profit entities that do not have a federal 501c tax exempt designation. Two, entities formed by U.S. persons solely to hold private property in the state, for example, a family residence. And three, local private social clubs that have formed entities with no intent to apply for federal 501c tax exempt status. The primary stated purpose of the CTA is to enhance measures to combat financial crime, such as money laundering and terrorism financing. Those are admirable and important aims. However, while attempting to fight crime, the CTA imposes its heaviest burdens on law-abiding U.S. citizens and permanent residents. The CTA's obligations to report sensitive personal information are imposed on a reporting company, even though one, the federal government does not know in what activities the reporting company is engaged or will engage. Two, the federal government does not know whether the activities engaged in or to be engaged in by the reporting company constitute commerce with foreign nations and among the several states and with the Indian tribes, such that they are subject to Congress's authority under Article 1 of the United States Constitution. Three, the federal government does not know or suspect that the reporting company is engaging in or will engage in any illegal activity or any activity that is subject to federal regulation. And four, the federal government has no suspicion of wrongdoing, probable cause, or any other basis justifying the imposition of an obligation to divulge sensitive personal information to FinCEN for law enforcement purposes. Thus, the CTA is a law enforcement dragnet of sweeping proportions imposed by Congress on law abiding U.S. citizens and permanent residents who own or control small businesses in the United States, as well as upon non business entities, where neither Congress nor any other branch of the federal government has established any legal or regulatory predicate to justify this demand for personal information. The statute compels self-identification of private individuals seeking to engage in or to continue engaging in lawful, federally unregulated commercial and non-commercial activity under state laws, allowing them to form an entity, whether or not such activity affects interstate, foreign, or Indian commerce. Compounding the error of this jurisdictional overreach, the CTA will likely weaken rather than strengthen the existing federal framework for collecting beneficial ownership information from economic actors in the U.S. financial system. The CTA will supplant the existing beneficial ownership reporting requirements under the customer due diligence requirements for financial institutions, the CDD rule, which requires financial institutions to obtain beneficial ownership information from persons or entities that voluntarily avail themselves of the U.S. financial system by operating a financial account with a federally regulated financial institution. Under the CDD rule, financial institution customers provide detailed and verifiable documentation demonstrating beneficial ownership information, subject to vetting and reporting of suspicious activity by the relevant financial institution. The CTA, on the other hand, requires no verifiable documentation, no review of the information submitted, and no monitoring or reporting to FinCEN by a disinterested third party. Making matters worse, The CTA will likely reduce the role of financial institutions, the very actors most likely to be used for improper financial activity and most equipped to detect and prevent such activity in combating financial crimes. Money laundering and terrorism funding are important U.S. national security problems, but the logical cure is to establish laws that follow the money, not to build a big brother database of predominantly U.S. citizens and permanent residents who are simply engaging in lawful activities. The framers of the Constitution conferred, as against the government, the right to be let alone, the most comprehensive of rights and the right most valued by civilized men. The CTA turns this bedrock principle of American freedom from governmental intrusion on its head. The act also claims to, quote, set a clear federal standard for incorporation practices, close quote, for entities formed under the laws of the states. 31 USC 5336, note 5A, and prohibits any state from authorizing any corporation, limited liability company, or other similar entity formed under its laws from issuing a certificate in bearer form evidencing either a whole or fractional interest in the entity. These are unprecedented federal intrusions into the state's sovereign powers to charter and regulate the formation of entities under state law. For more than 2 centuries, the states have had independent plenary authority to regulate the formation and internal structuring of corporate entities under state law, subject only to the constraints set forth in Article 1, Section 10 of the U.S. Constitution, that, quote, no state shall make any law impairing the obligation of contracts, which the Supreme Court has held to encompass corporate charters vested by the British Crown before the United States was established. The federal government does not have the constitutional authority to impose additional requirements on the formation of entities under state laws, nor to prescribe the conditions under which an entity charter may be granted under state laws. This includes banning one or more indicia of ownership, such as bearer shares, notwithstanding the power Congress possesses to regulate entities after formation if the entities once formed engage in foreign, interstate, or Indian commerce. The Constitution does not grant unlimited authority to Congress. Rather, the Constitution limits Congress's authority to the specific powers enumerated in Article 1 and the Civil War amendments, and reserves to the states and to the people powers not delegated to the United States by the Constitution. Consequently, the Constitution's enumeration of specific rights, quote, shall not be construed to deny or disparage others retained by the people. The CTA violates these constitutional principles. 1. The CTA infringes on the state's sovereign powers over the formation and governance of entities under state law. 2. The CTA does not regulate commerce. Rather, it imposes obligations on the states and state entity filers at the moment of entity formation, which is an entirely ministerial act, not a commercial activity, over which Congress can assert its power to regulate commerce. That's from the Commerce Clause. In fact, many states permit entities to be formed for purposes other than commerce or business. For example, the Alabama Code that they're quoting here, a domestic entity may have any lawful purpose or purposes unless otherwise provided by this title. 3, the CTA's application to all entities formed under state law sweeps in entities engaged solely in activities confined to the territory of the state in which they are formed, and entities that do not engage in any commercial activity at all. The CTA's indiscriminate regulation of entity formations therefore exceeds Congress's power to regulate interstate foreign and Indian commerce. 4, the CTA infringes upon individuals' right to apply for, form, own, and provide for the self-governance of entities under state law. By compelling individuals who apply for, form, own, or control entities formed under state law to identify themselves to the federal government, where the federal government has no basis for regulatory power, the CTA violates these individuals' constitutional rights to free speech and free association. 5. By compelling the disclosure of, quote, sensitive personal information for law enforcement purposes under penalty of criminal sanctions for noncompliance, and in certain cases, allowing federal and foreign government agencies to access such sensitive information regarding U.S. persons without U.S. court authorization, the CTA enables unreasonable searches and seizures of the right of the people to be secure in their persons, houses, papers, and effects, with no prior suspicion of wrongdoing, in violation of the Fourth Amendment. These aspects of the CTA also violate the privilege against self-incrimination and privacy rights protected by the Fifth and Ninth Amendments. 6. The CTA is unconstitutionally vague because its definitions of applicant and beneficial owner have no evident analogs in relevant state entity laws, provide insufficient notice of who is subject to its criminal sanctions for noncompliance, and vest too much interpretive discretion in the federal government. Therefore, plaintiffs seek declaratory and injunctive relief against the CTA's implementation to avoid an unconstitutional intrusion by the federal government into the rights of U.S. persons seeking to form corporate entities under state law and to protect the sovereignty of the states. The Act directs the Secretary of the Treasury to promulgate regulations to implement the statute. On September 29, 2022, FinCEN issued a final rule implementing the CTA's beneficial ownership reporting requirements to take effect on January 1, 2024 for newly formed entities and January 1, 2025 for existing entities. Consequently, immediate action by this court to enjoin the act and to declare it unconstitutional is necessary. Okay, so those are the facts under which this case has been brought. We see that they're raising a number of different constitutional questions and challenges to the constitutionality of the CTA. So this should be pretty interesting to see how this proceeds. Let me just introduce you to the parties. So the NSBA is an Ohio nonprofit mutual benefit corporation and is one of the leading and oldest associations of small businesses in the United States, with members in all 50 states and DC. The predecessor entity of the NSBA was formed in the 1930s to represent the interests of small business operators struggling to survive in the face of increased federal and state government taxes and regulations triggered by the Great Depression. Today, NSBA's mission is to represent and protect the rights of its members who operate their small businesses in compliance with lawfully enacted government regulation. Its members include numerous reporting companies owned or operated by U.S. persons who object to forced compliance with the CTA's unconstitutional command that they turn over, quote, sensitive personal information to the federal government to form or continue to operate entities formed under state law, requiring a diversion of resources from their businesses. NSBA joins in those objections on behalf of its members across the nation, including, so this is going to be examples of NSBA members. So one is a small software company that has developed a mobile phone app with no employees and less than $5 million in gross receipts or sales in 2021. Another one is a company formed to operate a retail food franchise with less than 20 full-time employees and less than $5 million in gross receipts. Another one is a single owner business consulting company with no employees. less than 5 million in gross receipts in 2021. Another one is a private family-owned real estate development company, some of whose owners hold their private residences inside a LLC formed under state law in the state where the residences are located, and a construction, electrical, and plumbing services company with less than 20 full-time employees and less than 5 million in gross receipts or sales in 2021. Moreover, because a primary mission of NSBA is to provide its members with information and advice regarding legal and regulatory issues faced by small businesses, NSBA has already incurred and will continue to incur substantial costs in assisting its members in understanding how the Act applies to them and affects their businesses. These costs and efforts will only increase now that the final rule has been issued. The individual plaintiff, whose name is Isaac Winkles, is a citizen of the state of Alabama and of the United States and a resident of Huntsville, Alabama. Winkles and his wife are the sole shareholders of Alabama Property Management, Inc., an Alabama domestic corporation that owns and operates a business managing real estate properties in northern Alabama. Alabama Property Management, Inc. is a member of NSBA, and Winkles will be subject to the Act's reporting requirements to give his sensitive personal information to FinCEN. He objects to being forced to comply with the Act as a violation of his constitutional rights and an encroachment on the sovereignty of the state of Alabama to regulate entity formation. The Supreme Court has held that individual citizens of a state have standing to raise claims that the federal government has infringed on a state's sovereignty. All right, then it goes into describing who the defendants are. So the defendant, U.S. Department of Treasury, is an executive branch department of the federal government headquartered in Washington, D.C., and is responsible for the administration and enforcement of the CTA through FinCEN. Defendant Yellen is the Secretary of the United States Treasury and is named as a party in her official capacity. And likewise, defendant Doss is acting director of FinCEN and is named as a party in his official capacity. Now, this entire factual allegations section, I believe, is going to outline the CTA, the requirements of the CTA, the reporting obligations, who is a beneficial owner, who is an applicant, company applicant, what is the sensitive information that's having to be provided, and the penalties for noncompliance. It is describing the database of personal information that's going to be held by the federal government, by FinCEN, which is collecting the personal information, the sensitive personal information for all of the beneficial owners of these estimated 33 million businesses in the US. Let me go over really quickly the allegations related to the database and who is going to be able to access the database and for what purposes. So in paragraph 22 here, titled Database of Personal Information, the disclosures required by the CTA will be used to create a vast database of personal information regarding beneficial owners and applicants. The CTA requires FinCEN to keep the personal data of a reporting company's beneficial owners and applicants for at least 5 years after the date on which the reporting company is wound down. For the duration of FinCEN's possession of the required personal information, which, given the lifespan of many companies, is likely to far exceed 5 years, FinCEN may share the reported personal data of reporting companies with federal, state, local, and tribal law enforcement agencies, with financial institutions for customer due diligence, with the reporting company's consent, and with a federal functional regulator or other appropriate regulatory agency, including foreign governmental agencies. So that's quite a lot of potential exposure that your information will have. If the request for personal data comes from a state, local, or tribal law enforcement agency, the statute, CTA, requires that it come through, quote, appropriate protocols, and that, quote, a court of competent jurisdiction has authorized the law enforcement agency to seek the information in a criminal or civil investigation. However, no court authorization is required if the request comes from, quote, a federal agency engaged in national security, intelligence, or law enforcement activity for use in furtherance of such activity. Likewise, if a federal agency makes a request for a beneficial owner or applicant's personal data on behalf of a non US law enforcement agency, prosecutor, or judge, for instance, pursuant to an international treaty, then FinCEN appears to have no explicit authority to deny the request, so long as the requested data is limited to the investigation or national security or intelligence activity that the foreign or international entity has in mind. Thus, for example, if a foreign government acting pursuant to a U.S. ratified treaty like the UN Convention Against Corruption, if they requested certain beneficial owners or applicants' personal data related to LLC owned real property located in the US, FinCEN is authorized to provide such data without any independent examination of the foreign country's need for the information. Going into burdens imposed on states. The CTA requires that relevant federal, state, and tribal agencies, as determined by the Secretary of Treasury, must, quote, cooperate with and provide information requested by FinCEN to create and maintain the intended database of sensitive personal information. While the Act contemplates that funds will be made available to states to alleviate the financial and other burdens imposed upon them by the CTA upon information and belief, so that means they don't have any facts yet, but they think this is what the case is, no such funds have yet been made available. According to the CTA, as a condition of the supposed funds, each state and Indian tribe shall, not later than 2 years after the effective date of FinCEN's reporting regulations, notify reporting company filers of the personal data reporting requirements and update relevant websites, instructions, and forms. However, because the penalties for individual noncompliance with the CTA, including upon state citizens and permanent residents, are so severe, and because the federal government itself has no ability to notify actual state level filers of the CTA's requirements at the time of formation, the states will be compelled to notify their citizens and permanent residents of the CTA's requirements to save them from fines and imprisonment, whether or not federal funds are actually made available. So this next section is the CTA's injurious impact on plaintiffs. What's the plaintiff's injuries? According to FinCEN, the reporting companies subject to the CTA will include approximately 32.6 million existing entities in 2024, plus roughly 5 million additional corporate entities created or registered under state law every year from 2025 to 2035, as well as foreign companies registered to do business in the US. However, the CTA excludes 24 categories of large business entities and companies, the broadest exclusion being for companies with more than 20 full-time employees in the United States, more than 5 million in gross receipts, and an operating presence at a physical office in the US. So, banks, insurance companies, all these highly regulated industries as well as existing shell companies with, as well as money transmitting businesses and existing shell companies with no foreign owners, assets, or active businesses are also excluded from reporting. Despite these broad carve outs, the CTA does not exempt reporting companies formed solely by US citizens or permanent residents, including small businesses with 20 or fewer full time employees and less than 5 million in gross receipts or sales, as well as entities formed for strictly intra-state commerce, that's within one state, not from state to state, strictly intrastate commerce or non-business purposes, such as entities formed to hold a family residence, for example, a high-profile individual wanting privacy for personal security reasons, entities that are formed with the intent to seek 501c federal tax exempt status but have um, not yet so, or nonprofit entities such as local private social clubs that do not intend to seek 501c federal tax exempt status. So those are all groups that will be subject to the reporting requirements. Nor does the Act contain any limitations that would restrict reporting obligations to individuals or entities that are suspected of a crime or wrongdoing. Therefore, the Act's burden will fall substantially and disproportionately on privately owned small businesses and non commercial organizations, regardless of whether there is any reason to believe that these small businesses and organizations have engaged in any misconduct whatsoever. The CTA will have profound and injurious impact on NSBA's members and small business owners, including plaintiff Winkles. Among other burdens imposed by the CTA, business owners may have to consult lawyers to parse through nearly 100 pages of the final rule to determine whether the vague and confusing reporting requirements of the CTA, or alternatively, risk interpreting such terms on their own. For directly by any quote standing quote exercises substantial control over an entity must be reported as a beneficial owner. Businesses cannot know the actual meaning of beneficial owner when the final rule defines it using vague terms such as understanding, arrangement, relationship, or otherwise. Rather than sharpen or narrow the definitions of these protein terms that do not appear in state entity formation laws, the final rule only compounds the confusion. The reporting obligations of the CTA have no obvious analogies in the existing laws of all 50 states, none of which appear to require the disclosure of personal information regarding applicants and beneficial owners. Well, that may be changing soon because I know that there are some states that are looking to implement their own statewide CTA laws. Check out New York, for example. For example, Alabama law requires only, quote, the name and address of each organizer of the filing entity, not their birth dates or active personal identification numbers as the CTA requires, and makes no reference to beneficial owners or applicants. And if the entity is to be formed is an LLC, the name and address of organizers is not required at all. In fact, based on plaintiffs' review of all 50 states' incorporation laws, no state appears to require birth dates or active passports, driver's licenses, or other such personal identification information for individuals who form an entity. Thus, the Act thus requires reporting of data to the federal government above and beyond what Alabama and most states currently require for entity formations in their respective jurisdictions, and without regard to whether the entity is engaging in commercial activity or generating income, such as the IRS requires for the reporting of such personal information for tax purposes. Many small businesses, including members of the NSBA, have tight profit margins, and the cost of compliance with the CTA's requirements will be considerable. A small business owner or applicant, say a small retail food franchisee, would first have to consult an attorney to see if he, she, or they qualify for a CTA exemption. If the answer is no, the relevant person or persons in charge of the reporting company would have to determine who its beneficial owners are. Determining beneficial owners would be no easy feat with respect to many reporting companies, such as those formed to hold real estate. Example, a family vacation home held by an LLC. Shares in the title to which may be dispersed among family members of multiple generations. Furthermore, because the necessary sensitive personal data regarding beneficial owners would have to be updated, affected small businesses, property holders, and other persons may have to consult attorneys again when their circumstances change. In addition to the countless hours that millions of Americans operating small businesses or affiliated with non-commercial entities will have to expend to read and understand the CTA and its regulations, these Americans will likely have to pay hundreds or even thousands of dollars to attorneys to navigate the statute's labyrinthine reporting requirements. The threat of such crippling federal regulatory overhang on small businesses was the precise reason why NSBA was formed in the first place. The CTA contains no provisions to protect individuals who have formed or would form entities for associational or similar reasons without seeking or having yet applied for 501c federal tax exempt status, such as local all-women social club formed to discuss current health, reproductive rights, and sexual orientation issues in a confidential group setting. In doing so, such persons are exercising their constitutionally protected free speech and association rights. The prospect of reporting their sensitive personal information to FinCEN may deter or chill such persons from participating in the management of the entity in a significant way, and thereby risk being classified as a beneficial owner or applicant because of fear of exposure of their beliefs or activities. These concerns are substantial, given the fact that the statute encompasses potential access to the personal information even by foreign governments, such as a Chinese government request for information about the beneficial owners of an entity established under state laws by U.S. persons to protest Chinese government policies. The burdens the CTA imposes upon entity formation in every state will have a direct, predictable impact on NSBA itself. An important service NSBA offers to its membership is the provision of information, education, and assistance regarding legal and regulatory compliance issues faced by small businesses. The benefits of the CTA do not justify the burdens it imposes on small business owners. To the contrary, the CTA does little to effectively combat financial crime and is inferior to the existing CDD rule, which is what financial institutions follow. The CTA was enacted to supplant existing beneficial ownership reporting requirements under the CDD rule. The CDD rule requires financial institutions to develop and update a risk profile specifically for anti-money laundering and illicit transaction purposes for every customer and obtain documentary and verifiable beneficial ownership information, including formation and governance documents, passports, driver's licenses, home addresses, trust agreements, or other information. The information submitted under the CDD rule is reviewed, vetted, and verified by compliance staff of covered financial institutions. Furthermore, these financial institutions have an ongoing obligation to monitor client relationships and report suspicious activities to FinCEN. The CTA, on the other hand, requires no supporting documentation, no review of the information, and no third-party monitoring or reporting to FinCEN about suspicious financial activity. Without a disinterested intermediary to make sure that filers are making full and accurate disclosures, bad actors will manipulate or avoid disclosure requirements, undermining the purported purpose of the CTA. The likely result is that the CTA will simply create a database containing personal information about law abiding reporting companies and their owners, who will predominantly be U.S. persons, not the foreign individuals and entities engaging in money laundering and illegal activities that the statute was designed to target. The CTA is nothing more. This is The CTA is nothing more than a first salvo in a campaign to transfer responsibility from the very institutions, big banks, that process the targeted illicit transactions to law abiding small business owners. It is a quintessential example of the government prioritizing Wall Street to the detriment of Main Street. Plaintiffs fully support Congress's desire to attack money laundering and terrorism financing, but passing an unconstitutional statute penalizing hardworking U.S. small business owners is not the answer. And here for the causes of action. Count 1, unconstitutional usurpation of the state's power to regulate entity formations in excess of Congress's constitutional powers. So, in a nutshell, that means that it's unconstitutional to usurp the power of the state to regulate entity formations, and that overstepping basically oversteps Congress's constitutional powers. So this is going into the states have independent authority to charter corporations and regulate businesses back 1776 Constitution. It's going back to formation. One of the enumerated powers of Congress, and perhaps the most heavily used of those powers in recent decades, is the power to regulate foreign, interstate, or Indian commerce. Congress can also wield its taxing power to tax income earned by individuals through corporate entities, as it currently does through federal income taxes on corporations. However, Congress has no regulatory interest or constitutional authority over corporate formation because a reporting company has not yet engaged in any foreign, interstate, or Indian commerce at the moment of its inception. The formation of an entity under state law is an entirely ministerial act, and many entities will engage in no activity until some indeterminate time after they've been formed. That's a good point. Skipping down to 48, this fact exposes a fundamental flaw in the CTA structure. The CTA does not regulate any specifically identified commercial activity. So Congress has the constitutional power to regulate interstate commerce, yet the Corporate Transparency Act does not identify any commercial activity that they're trying to regulate. So that's another argument. Here's another argument. The CTA commandeers state agencies by coercing states into giving notice to state filers of the CTA's reporting requirements and providing filers with a copy of the CTA filing form. So they're basically saying that that CTA is forcing itself upon the states to do FinCEN's job, basically, to inform the people that are registering or forming a new entity within that state. It's putting a burden on the state to provide the information about the CTA to those new entities. Let's see what this says. Because the states are the only agents capable of providing notice to entity formation filers at the time of formation, states are likely to feel compelled to provide the notice in the FinCEN filing form to protect their citizens from the severe criminal penalties that would result from failure to comply with the CTA's filing requirements. Through these requirements, the CTA violates plaintiffs' rights and all rights of the NSBA members by exceeding the enumerated powers of the federal government set forth in Article 1, Section 8 of the Constitution of the United States, violating the Ninth and 10th Amendments and violating the constitutional principles of federalism and retained state sovereignty upon which this nation was founded. Plaintiffs are requesting that the court declare CTA to be unconstitutional, that they declare that the CTA exceeds Congress's authority under Article 1 of the Constitution, that it encroaches upon the state's respective sovereignties in violation of the Ninth and 10th Amendments and the constitutional principles of federalism and retained state sovereignty. And it's asking the court to enjoin the defendants from enforcing the CTA. Count 2 is unconstitutional invasion of privacy, unreasonable search and seizure violation of the Fourth Amendment, compelled self-incrimination violation of the Fifth Amendment, right of privacy violation of the Ninth Amendment. So we kind of already got an outline of these allegations. Sorry, we already got an outline of these allegations at the beginning of the complaint, but here is the actual request for relief in count 2 under those legal theories. The CTA is a statute providing for criminal punishment enacted for the purpose of harvesting sensitive personal information from individuals to create a database for law enforcement purposes by FinCEN and other U.S. and foreign law enforcement and intelligence agencies. No matter the degree of invasiveness, suspicionless searches and compelled disclosures are never allowed if their principal end is crime solving. Privacy is often a key motivation in state entity formation. No state has chosen to require the extent of disclosure of beneficial ownership and applicant information upon filing that the CTA is now mandating. The CTA's requirements violate that expectation of privacy by compelling the disclosure of that information, the sensitive information, by individuals protected by the Fourth, Fifth, and Ninth Amendments. The CTA contains no limitations on the provision of the required personal information to situations where there is an articulable, individualized suspicion of a crime or wrongdoing by such beneficial owners and applicants. The CTA also authorizes the provision of private personal information to foreign governments, federal regulators, and regulatory agencies without any court authorization or special requirements regarding those agencies' need for the information. By requiring, under threat of criminal penalty, criminal and civil penalty, but I mean, I guess criminal penalty is worse, reporting companies, by requiring reporting companies to provide individual sensitive personal information for law enforcement purposes in the absence of specific prior indicia of wrongdoing, the CTA deprives plaintiffs and the members of the NSBA of their privacy rights and violates the Fourth, Fifth, and Ninth Amendment of the Constitution of the U.S. By compelling disclosures and permitting the release of sensitive personal data to federal and foreign government agencies without the reporting company's consent or authorization from a court of competent jurisdiction, the CTA violates the Fourth, Fifth, and Ninth Amendment rights of plaintiffs and the members of the NSBA. Plaintiffs request that the court declare, again, the CTA to be unconstitutional, declare that the CTA violates the Fourth Amendment's reasonable expectation of privacy from unreasonable searches and seizures without probable cause or articulable suspicion. Declare that the CTA violates the Fifth Amendment's privilege against self-incrimination. Declare that the CTA violates the Ninth Amendment's retention of unenumerated rights to the people. And ask the court to enjoin defendants and any other agency or employee acting on behalf of the United States from enforcing the act against the plaintiffs, and to take such actions as are necessary and proper to remedy their violations deriving from any such actual or attempted enforcement, and to award plaintiffs their costs, because lawyers aren't cheap. Count 3, compels speech and unreasonable burdens on the freedoms of speech and association. Plaintiffs reallege and incorporate by reference each of the complaint's allegations. These are going to be the factual allegations that we saw at the beginning of the complaint. Under the CTA, the obligation to report personal information to the federal government arises at the time of formation of an entity under state law. The CTA forces filers to disclose more personal information to the federal government than what is required to be disclosed under state entity formation statutes. State laws providing for entity formation, however, reflect the state's respective judgments that the provision of such information is not a necessary or appropriate prerequisite of entity formation. So this is saying again that some people aren't going to use an entity for commercial purposes. Some are nonprofits that are not trying to seek out a 501c designation. And many of them are just individuals who want to have their information private. Nevertheless, the CTA compels such entities and individuals to publicly reveal their associations to the federal government, which may in turn transmit that information upon request to all of these other people: federal and state law enforcement agencies, courts, prosecutors, foreign governments, law enforcement authorities, financial institutions, federal regulators and regulatory agencies. This forced disclosure will also deter such persons from exercising their rights of free speech and association, and dissuade others from joining or assuming leadership positions in the entities, and thus arguably becoming beneficial owners. The U.S. does not have a compelling overriding interest in obtaining the information required by the CTA because less onerous alternatives are available to accomplish the stated goals of the CTA, and the methods employed by the Act are not narrowly tailored for their specific purpose. To wit, the most obvious and direct way to stem money laundering and international terrorism funding is to ramp up regulation and scrutiny of large cross-border money transfers, for instance, by banks, financial agents, and escrow agents. Vacuuming up personal information about every American who sets up or has a significant stake in a corporate entity is overkill, given the CTA's stated aims. The requirements of the CTA are neither justified by nor necessary to promote the stated goals of the CTA. Let's see. By requiring under threat of criminal sanction plaintiffs and all members of NSBA to disclose information in the manner mandated by the CTA, despite the availability of less onerous alternative methods to achieve the statute's stated goal, the CTA disclosure requirements constitute compelled speech in violation of the First Amendment to the Constitution of the United States. by requiring U.S. persons who have formed or wish to form a legal entity to engage in protected speech, despite the availability of less onerous alternative methods to achieve the stated goals of the CTA. The CTA violates the First Amendment by burdening the right to speech and private association. Narrow tailoring is crucial where First Amendment activity is chilled, even if indirectly, because First Amendment freedoms need breathing space to survive. And that's a quote from the Supreme Court of the United States. Plaintiffs request the CTA, again, to be declared unconstitutional in violation of First Amendment right to speech and private association and its prohibition on compelled speech. And it's asking that the defendants be enjoined from enforcing the CTA. Count 4. How many counts are there? Hold on a second. This has got to be it, right? Yeah. All right, count 4. We're on the home stretch. We're on the home stretch. If you're still here, thank you. That's all I have to say. You're my ride or die. All right, count 4. Let's finish this up. Unconstitutional violation of due process. Both the CTA and the FinCEN rules relating to CTA fail to provide definitions specific enough for plaintiffs to understand what conduct is required to avoid criminal sanctions. They already talked about all the vague words and all the vague terminology. So, in addition, the CTA's overall framework for mandatory reporting, updating, access, and record keeping is so vague and complex that plaintiffs, members of the NSBA, or other ordinary small businesses or non-business entities cannot reasonably comply with these requirements. And we do know that there are a lot of requirements for maintaining the information after the initial BOI report is to be filed. If there are any changes in company information of any of the beneficial owners or of the reporting company itself, those changes must be made with FinCEN on the platform within 30 days of those changes occurring. Should plaintiffs, members of the NSBA, or other ordinary small businesses or non-business entities be forced to attempt to comply with the vague and complex requirements of the CTA, they will be forced to incur substantial costs and other burdens. So they already talked about having to seek out legal assistance in determining who beneficial owners are, and then continued retaining attorneys as the dynamics of the company change. The stated goals of the CTA do not justify the enormous burden it places on small businesses and non-business entities and can be accomplished through less onerous alternative means. By subjecting plaintiffs and all other individuals covered by the CTA to potential criminal sanctions without adequate notice of the actions required to avoid the sanctions, and by the same token, expanding the federal government's discretion in enforcing the requirements, the CTA violates the Due Process Clause of the Fifth Amendment to the Constitution of the United States. So this is saying that the CTA is so vague that we basically don't have notice. And when I say we, I'm talking about small business owners or business owners in the US that are going to be subject to CTA. We have no notice of what actually we need to do in order to comply perfectly with the CTA. And not only that, but the federal government is being given discretion in enforcing how, when, why, where these enforcement of penalties is going to occur as a result of, those two factors. They're saying that the CTA violates the due process clause of the Fifth Amendment. And like the other counts, they're requesting the court declare the CTA to be unconstitutional, violative of the due process requirements of the Fifth Amendment. They're asking for an injunction against the defendants from enforcing the act and for costs. So this was dated and filed November 15, 2022. By these attorneys out of Alabama. It was filed in the Northern District of Alabama. So where are we now with the case? Let me log into my Paystar account really quickly and see if there's any updates. Okay, here we go. So I've logged into my Paystar account. I just did it off screen so that I wasn't showing my login information. But let's search for the actual case. So excuse me. So there were proceedings on November 20th. There's a transcript for the motion that was held. So that's all we have here. So the motion that was held at the end of November was going to be on the defendant's motion to dismiss and motion for summary judgment. Which I may go through on another day, because it looks like there were a lot of exhibits to go through. Those can sometimes be fun to look at. So I may go through those motions another day, and then we should have the transcript somewhat soon, but we'll see. Okay. All right. Well, I guess that's going to be it for now.
So to summarize, we have an association of small businesses as well as one individual business owner who are the plaintiffs. They sued the government, arguing that the CTA violates the Constitution in multiple ways. Count one, they allege that Congress did not have the authority to enact the CTA because Congress can only regulate commercial activity, and the CTA does not specifically address commercial activity. They further alleged that the CTA commandeers or forces the 50 states to provide the residents and the entities formed in the state with information about the CTA and the penalties for noncompliance. Count two, they allege that the CTA violates the Fourth Amendment's reasonable expectation of privacy from unreasonable searches and seizures. They say that by requiring personal sensitive information of all beneficial owners without probable cause or articulable suspicion of a crime or wrongdoing by them, the beneficial owner's privacy is being violated. They further allege that by requiring the personal information, the plaintiffs allege a violation of the Fifth Amendment's privilege against self-incrimination. Count three, the plaintiffs allege the CTA violates the First Amendment's right to free speech and private association and the prohibition against compelled speech. They argue that the way the CTA is requiring beneficial owners to disclose information can be done in a less burdensome alternative way. And by the current disclosure requirements, requiring disclosures constitute compelled speech. They go on to argue that private associations, which we know can be formed for controversial topics, will be dissuaded from organizing because of the disclosure requirements, and thus the CTA is chilling free speech. Finally, in count 4, plaintiffs allege that the CTA violates the Due Process Clause of the Fifth Amendment because aspects of it are either vague, overbroad, or just too complex to give those impacted by it fair notice of the actual requirements and how to avoid the penalties. In each of the 4 prayers for relief, the plaintiffs request the court to declare the CTA unconstitutional, enjoin or stop the defendants from enforcing the CTA, and for plaintiffs' costs. So what we did not cover today was the government's motion to dismiss / summary judgment in response to the complaint. We do know that there was a hearing on that motion on November 20th. Now, federal courts don't generally allow cameras in courtrooms, so we're just going to have to wait for the transcript to be released to learn how that hearing actually went. And the transcript probably won't be released until the end of February. And of course, there's no order published yet. But my initial thoughts are that there's no way the motion to dismiss or summary judgment will be granted at this point in the matter, assuming the jurisdictional requirements have all been met. Although, if it was granted, that would provide a way to move it up the line in the appellate process through the court system and possibly up to the Supreme Court. I doubt anything definitive is going to happen before January 1, 2024, when the CTA will go into effect. So by all means, please continue with your planning efforts and preparing to comply with the reporting requirements. Now, like I mentioned before, if you want more info on the Corporate Transparency Act, whether it applies to your business, who the beneficial owners are, how to figure that out, what are the requirements, check out my playlist. If you're a small business owner and you want legal tips, updates, and general advice about how to proactively protect your business assets, hit that subscribe button. Leave me a comment to say hello and stay tuned. Until the next drop.